Afternoon, everyone. This is Kristen O'Neill with the New York State Committee on Open Government. This afternoon, we're going to do an overview of the New York State Open Meetings Law and any updates or refreshers for anyone who maybe hasn't taken a program in a little while. We'll talk about what's been new in the past few years. In the chat feature, I put a link to the where this program will be recorded and posted on the Committee on Open Government's training YouTube page. So I put in the chat feature a link to our YouTube page, as well as where you can find PDF copies of PowerPoint presentations for both the Freedom of Information Law and the Open Meetings Law. So I'm going to, just to be 100% sure, because this morning I had a little bit of trouble. I just want to, if someone, I'm going to ask anyone to put a note in, just making sure that they can hear me. Okay, so I think people can hear anything, but they don't see the link. So maybe if because I put it in the system before some people join, so I'm going to put it in the system again. I'm going to put it in the chat feature again. Okay, let's see. Okay, I think what happened is if people joined after I put the link in chat, it didn't show for them. So hopefully everyone can see it now, and I can hopefully I'll try to remember to maybe do it one more time at the end. So, all right, so we'll get going. Morning, people were with me. We talked about the Freedom of Information Law. Now we're going to talk about the Open Meetings Law. For those of you who are maybe not as familiar with our office, the staff of the Committee on Open Government is housed at the Department of State. So we've got a staff of our executive director, Shoshana Boulay, myself, I'm deputy director and counsel. We have a senior attorney, Kristen Smith. We have Excelsior fellow, Miguel Carlo Batista. We have our administrative analyst, Ellie Baird, who is new to our office. She's going to help us with some modernization of our website, specifically trying to make the information available in our advisory opinions more accessible. And we have our administrative assistant, Candace Watson-Cottle. So that's our entire office. If you have questions about the Freedom of Information Law or the Open Meetings Law, we are an open resource. So you can call the phone number that you see up there, the 518-474-2518. The legal question you can ask to speak with an attorney. If you think it's just really a more practical question, you can just screen it out. We'll see. But anyway, you're more than welcome to always just ask to speak with an attorney. You see our website there, that is www.opengovernment.ny.gov. And if you'd like to email us a question, sometimes when something's a little bit more complicated, or if you'd like us to look at some documentation, sometimes that makes things a little bit easier, you are more than welcome to email us at coog@dos.ny.gov, COOG being our acronym, and we'll take a look at what you send over and offer our guidance and opinions. This is what our website looks like. There's lots of helpful information up there under Freedom of Information Law. You can see the text of the statute, the regulations, our advisory opinions. Same goes for Open Meetings Law. If there have been any amendments or information that has come out recently that we think is helpful to the public about the open government statutes, we're going to try to get that up there on our website, either on the large banner where you see the Capitol building or the small white banner. We use those banners to our advantage to try to, anytime there's anything new and exciting in the world of open government. So the Open Meetings Law was passed in 1976. The legislative intent stated that it is essential that public business be performed in an open and public manner, and that citizens be fully aware of and be able to observe the performance of public officials. Citizens have the right to attend and listen to the deliberations and decisions that go into the making of public policy. So the goal here is, in addition to being able to attend meetings of our town boards and city councils and county legislatures, and seeing them vote, we also want to be able to attend these meetings and watch the deliberations that go into decision making. We want to see people who have different opinions have conversations with each other and come to some sort of consensus. And maybe it's not always going to be consensus. Maybe there is always going to be a side that wins on a particular issue and a side that doesn't win. But the point is that the public has the right to see it all happen, not just the decisions, not just the votes, but the deliberations and discussions that lead up to the votes. The Open Meetings Law governs meetings of public bodies. So what is a public body? A public body is an entity for which a quorum is required in order to conduct public business. So we're talking about government entities here. It has to consist of 2 or more members performing a governmental function either for the state, for an agency or department of the state, or for a public corporation as defined in general construction law. So public corporations include most municipalities, counties, cities, towns, villages, but also school districts. And then on top of that, you have entities. The definition goes on to include entities created or appointed to perform a necessary function in the decision-making process. So that might include planning boards, zoning boards of appeals, boards of assessment reviews, other types of entities that are an essential part of our government functions. In addition to the full public body, such as, let's use for an example, a city council. Let's say we have a 9-member city council, and you designate 3 of those individuals to serve on a particular committee. So you have a 3-member finance committee within the city council. That 3-member committee, by definition, has now become its own public body subject to the Open Meetings Law. So you have the full public body is subject to the Open Meetings Law, and any committee or subcommittee consisting of members of the public body is also a public body. Law was amended in February of 2022 to address situations for sort of non-traditional public bodies. It talks about entities that perform a function established by statute, where basically, let me give you an example here. Earlier this year, we had a question about an entity out of Western New York. If you'll recall, a couple of years ago, we had the sad situation of shooting at a Tops supermarket out in Western New York. And after that happened, there was a desire to honor the individuals that passed, and a commission was created to decide how that was going to occur. And this commission was created by statute, and the governor, the state set aside money for them to build a monument. And the committee, the advisor, excuse me, the commission that was created was given the authority to decide who was going to build the memorial, and was given the authority to decide who was basically, they were going to be able to take state money and decide how that money was spent in terms of this memorial. So they were really given quite a bit of authority by this statute. So it's a non-traditional public body, but because they were given all of this authority by statute, they were determined to be a public body subject to the Open Meetings Law. I'm not great at multitasking throughout the entire, so I can't necessarily take every question as it comes in, but I would like to maybe take breaks periodically, maybe every 10 minutes or so. I'll take a break from the presentation. And so if you have questions about what I'm talking about, feel free to put it in the chat feature, and then I'll take those breaks and we can maybe address those questions. And if you ask a question that I'm going to get to, I'll just let you know. In 2022, the Open Meetings Law was amended to expand the use of video conferencing by public bodies. Public bodies have been allowed to use video conferencing for many years now. Even pre-COVID, there was a provision of the statute that allowed public bodies to take advantage of video conferencing technology to conduct their meetings. But pre-COVID, the only way to use this video conferencing and to comply with the statute is to have multiple open locations where your board members were attending from. The location had to be noticed to the public, and so that, like, the address, for example, of each location had to be included in the meeting notice, and the public had to be advised that they were entitled to attend from any of these locations. So anywhere there was a board member, that location had to be open to public attendance. And then all of these locations would be connected through the use of video conferencing. So for example, when the Committee on Open Government had its meetings, we would set up a meeting location in Buffalo, Albany, and New York City, and we would connect those locations through the use of video conferencing. So our board members would choose which location was most convenient for them. We would put out a notice to the public saying you're welcome to attend at any one of these 3 locations. So that's been in effect for many years now, pre-COVID. And then, of course, as we all recall, during COVID, there was provisions of the Open Meetings Law that were suspended. The in-person requirements of the Open Meetings Law were suspended during the COVID public health emergency, where public bodies were permitted to have completely remote meetings. Everything could be online. Everything could be through the use of either teleconference or video conference or live streaming, some type of remote access. And the in-person requirement was suspended. And this was in effect for quite a while through the fall of 2022. In the spring of 2022, legislation was passed that expanded the use of video conferencing to conduct meetings, where a member of a public body was permitted to attend a meeting via video conferencing from a private location, from a closed private location, but only if they were experiencing an extraordinary circumstance. So 2 ways to conduct video conferencing. One is where you're connecting multiple physical locations that are open to in-person public attendance. And 2 is where you're allowing a member of a public body to participate from a private location through video conferencing under extraordinary circumstances. There's a lot of requirements if a public body wanted to take advantage of these new provisions. There was a lot of things that they needed to do. There's sort of a lot of hoops that needed to be jumped through. But if you just want to continue acting as you did pre-COVID, you didn't have to do anything as a public body. You could just continue doing what you used to do. If you used to have multiple physical locations that were open to the public and they were connected through video conferencing, you continue to do that, and you didn't have to pass a local law, you didn't have to pass a resolution, you didn't have to do anything. You only had to take all these sort of additional steps if you as a public body wanted to take advantage of the new provision that allowed your members to attend from private locations. So I used the term extraordinary circumstance earlier. So a member could only attend from a private location if they were experiencing an extraordinary circumstance. Otherwise, they were expected to attend the meeting in person. What is an extraordinary circumstance? The Open Meetings Law defined it to include disability, illness, caregiving responsibilities, or any other significant or unexpected factor or event which precludes the member's physical attendance at the meeting. The language of this amendment that was passed in 22 clearly gives an indication that the legislature has a preference for in-person meetings. They're not necessarily making it easy for public bodies to take advantage of this new provision that allows someone to attend from a private location. For example, except sorry, I'm losing my train of thought a little bit. With a limited exception, the only people that count towards a quorum are the people that are in person at public locations. Someone attending via video conferencing from a private location does not count towards a quorum unless they're experiencing a disability that prevents them from attending in person. So I'm using the term quorum up on the screen now. You'll see this is the statutory definition of quorum. So when you think about quorum, you think about how many people should be on this public body if it was at full strength. So for example, our Committee on Open Government is established by statute. There's a definition of what the Committee on Open Government, who must serve on the committee, like what qualifications they have, who gets to appoint them. And it established is that it's an 11-member body at full strength. So a quorum of the Committee on Open Government is always going to be 6 people. It doesn't matter how many people are currently serving on the committee. Like at certain points, we dropped down to 8 or 9 people due to lack of appointments. But it didn't matter how many people were currently serving on the committee. It only matters how many people should be on the committee. So when we look to see what a quorum should be, you look at that full 11 people. Or if you're talking about a 5-member town board, you're always going to say, okay, a quorum of 5 is going to be 3 people. It's a majority of the total memberships. A 5-member board has a 3-person quorum. A 7-member board has a 4-person quorum. A 9-person board has a 5-person quorum, and on and on and on. Law was amended again in the spring of 2023 to state that if you had a disability that prevents you from attending in person and you wanted to attend via extraordinary circumstances video conferencing, then you could count towards a quorum. So this slide that you see on the screen right now, it sort of goes down, breaks it down as to who does count towards a quorum and who doesn't. So if you're participating from a physical location that's been properly noticed and is open to in-person and public attendance, you do count towards a quorum, and you can fully participate and vote during the meeting. If you are a member who is video conferencing up from a remote location that's not open to in-person public attendance, you don't count towards a quorum unless you meet the disability criteria. However, once you have a quorum, the members attending via video conferencing can fully participate and vote. Someone just asked in the chats whether you can ask questions at any time. I think I mentioned a little while ago that I'm going to be taking 10-minute breaks. So I'll get to that break in just a little bit. You can type your questions into the chat feature at any time. I'm just not going to, I will only take breaks at certain points to answer those questions. It will look right now. Someone asked a question someone asked about personal privacy exemptions applying to records of investigations relating to deceased. That's entirely a FOIL question, which would have been for this morning. This is an open meetings law presentation, so we won't, if this person would like to contact us directly with their question about relating to FOIL, you can email it to the COOG inbox. Someone asked a question about how many times the quorum disability criteria be used by a voting member during the calendar year. It's not addressed by statute. I think the question is, how many times can the quorum disability criteria be used by a voting member during the calendar year? I can't imagine that there's a limit. First of all, you have to keep in mind that if you want to take advantage of this provision as a public body, governing bodies of municipalities have to pass a local law. All other public bodies have to pass a resolution, and then you have to have procedures in place. So those public bodies can establish procedures, but the open meetings law itself doesn't establish limits on how many times somebody can take advantage of these provisions. That's something that would have to be established by each public body according to their own local law, resolution, or procedures. Someone's asking me a question about whether I'm aware of a particular Senate bill. You know, we track quite a bit of legislation. Yes, we track quite a bit of legislation. We pay attention to those. If you look at our annual reports, we talk about a lot of legislation that may impact the Freedom of Information law and the open meetings law. And we certainly, if something has traction, it's something we're going to pay close attention to. Someone says, if a member is away on a business trip in a hotel, do they count towards a quorum? So I'm going to go back to the slide. We're going to go back. We're going to look to see who has a quorum, who counts towards a quorum, and who doesn't. Members who are participating from a physical location that's been properly noticed and is open to in-person public attendance do count towards a quorum and may fully participate and vote. Members who are participating from a remote location that's not open to in-person public attendance do not count towards a quorum. So if someone's on a business trip, in order to count towards a quorum, they would now need to notice their location and make their location open to the public. I'm going to ask people to limit their comments in the chat feature to actual questions they would like answered, as opposed to maybe something more specific. Like, for example, this, a question about, possible legislation. It's not really something I have time to address during a general presentation. So I guess I'll ask to limit it to questions about the presentation. Someone said, I thought OML applied to committee meetings of a public body only if the population exceeded 1 million. No, that is not true unless you're a library. If the person who's asking the question is a library, that is true of association and free libraries. That is the only time the population matters. Can the public body expand the definition of extraordinary circumstances to include other circumstances beyond those defined by the law? As long as it sort of meets the definition. So the way the open meetings law talks about, including disability, illness, caregiving responsibility, or any other significant or unexpected factor or event which precludes the member's physical attendance at such meeting. So if you want to expand beyond, for example, disability, illness, or caregiving responsibility, the extraordinary circumstance, by its very name, it has to be not an everyday, I'm on a work trip. It has to be an extraordinary circumstance. If it's not an extraordinary circumstance, I mean, if public bodies were allowed to extend it to almost anything, it would sort of make this all sort of a moot point. But it has to be due to an extraordinary circumstance that is significant or unexpected. That's the way it can be. If you can expand your definition to include other examples of significant or unexpected factors, yes, the public body could do that. Disability is defined in New York State Executive Law, Section 292. So the person said, yes, we are a library, association library. So that's very narrow scope of who we're dealing with today. So apologies, but yes. So if you are an association library, then the open meetings law only applies to your committees if you're a population of 1 million or more. But for everyone else who's on this program who's not an association library, it doesn't matter. Population is not relevant. Okay, let's see. Go back to our slideshow. Notice of all meetings must include the date, time, and location, and if appropriate, instructions for virtual attendance. Notice must be given prior to every meeting to the media. This does not mean that the public body has to purchase a legal notice. It just means that the media needs to be notified. My recommendation is to have some sort of written record of the notification in case you need that for cover yourselves. But basically the law just says notification must be given to the media. Must be placed in a designated physical location. So for example, if you have a bulletin board or signs, things of that nature, you want to post your meeting notices in your designated physical location. And if your agency or public body has an active website, the notice should be posted on your website. In terms of timing, notice must be provided at least 72 hours prior to any meeting that is scheduled at least 1 week in advance. For meetings on short notice, notice must be given to the extent practicable at a reasonable time prior to the meeting. So there's two sets of timing for notices. One is, I suppose, for regular meetings, and one are meetings that need to be held on short notice. The open meetings law itself does not state when you're allowed to have meetings on short notice, but the courts have. The courts have weighed in and stated that the propriety of scheduling a meeting less than a week in advance and providing less than 72 hours notice is dependent upon the actual need to do so. So a public body should not be having meetings on short notice if there would be no harm in waiting and providing the full amount of notice and conducting business at the next regularly scheduled meeting, for example. If extraordinary circumstances video conferencing is going to be used, the public notice has to inform the public that video conferencing will be used, where the public can view or participate in the meeting, where required documents and records will be posted or available, and identify the physical location or locations where the public can attend in person. In the fall of 2021, there was a flurry of activity relating to the open meetings law, and there was several bills passed during that time period. One of them relates to records scheduled to be discussed during an open meeting. So the governor signed Chapter 481 of the laws of 2021, which amended Section 103E of the open meetings law to require that records to be discussed at an open meeting be made available to the extent practicable upon request and posted online. So it's not that they only have to be posted online if there is a request. It's upon request and they have to be posted online at least 24 hours before the meeting if the agency maintains a regularly and routinely updated website and utilizes a high-speed internet connection. So the obligation to make records available to the public upon request prior to or at the meeting and to post the records on the website prior to the meeting had been in effect since February of 2012. This amendment from the fall of 21 only placed a 24-hour minimum time frame for making those records available. So it wasn't a huge change, it was just a time frame. My experience is that when this law was amended, a lot of people were taken by surprise and seemed to think that this was a new obligation when in fact it had been at that point an obligation for close to 10 years. So what types of records are we talking about? Proposed resolutions, laws, rules, regulations, policies, or any amendments thereto. Those are required to be made available upon request and posted online to the extent practicable at least 24 hours prior to the meeting. Any records or portions of records that would be available under the Freedom of Information law that are scheduled to be discussed during the open meeting all need to be made available prior to the meeting, at least 24 hours prior to the meeting upon request and posted online to the website. This does not apply to records discussed in executive session. Minutes of all meetings of a public body must include a record or summary of all motions, proposals, resolutions, or any matter formally voted upon and the vote thereon. If extraordinary circumstances video conferencing is used, it must include which, if any, members participated remotely. A public body is only required to prepare minutes of an executive session if it votes in executive session. If it merely deliberates in executive session and then comes out and votes in public or doesn't vote at all, then no separate minutes of the executive session need to be prepared. Minutes must be made available within 2 weeks for an open session and 1 week for an executive session. Doesn't matter whether those minutes are unapproved or still in draft form. In fact, the open meetings law doesn't really talk about approving minutes. There's nothing in the open meetings law that requires a public body to vote to approve minutes. That's a standard operating procedure, and I'm not discouraging any public body from taking those steps. I'm just saying that it's not a statutory requirement. So once those minutes have been prepared, they must be made available to the public regardless of whether they've been approved or not. In the fall of 2021, the governor signed Chapter 587 of the laws of 21, which amended the open meetings law to require agencies that maintain a website and use a high-speed internet connection to post their meeting minutes on their website in 2 weeks of the date of a meeting or 1 week of an executive session. The law states that for purposes of the posting requirement, so this is just about the posting requirement, not about creating the minutes in the first instance, just for posting purposes. A public body can post an unabridged video recording or unabridged audio recording or an unabridged written transcript in lieu of meeting minutes. However, you still need to prepare minutes. So I'm not really sure what the benefit is of posting unabridged recordings or unabridged transcripts in lieu of posting meeting minutes. However, you can still do that, but you still need to prepare the meeting minutes and must be made available upon, those minutes must be made available upon request. Let's see, we'll look at questions in a minute for a second. Question is, does the recording have to be posted following the meeting if there was a quorum at the physical site and only one person participated by video conferencing? Okay, so this is a requirement of the statute. If any of your members are participating via extraordinary circumstances video conferencing. So in this situation, you had one member participating due to extraordinary circumstances video conferencing. So all of the requirements of section 103-A kick in. And one of those requirements is that the video conference be recorded and posted to the website within 5 business days. I recall, I apologize, it's not in my slides, but I can look it up if someone needs it. It has to be posted to the website and it has to stay on the website for 5 years. We at the committee use YouTube sort of as our host. So if you go to our website and look for our committee meetings, you're going to find a link to YouTube. So YouTube sort of, it's their storage that we're taking advantage. We have a YouTube account. You link to, you go to Committee on Open Government's website. The Committee on Open Government's website then brings you to the YouTube page where those videos are stored. Next question is, if a town board regularly schedules workshops with presenters but doesn't post materials 24 hours prior using the excuse that board members themselves haven't seen the presentation, is that a violation? So the first thing I'm going to tell everybody on this meeting is that the Committee on Open Government is not empowered to determine whether violations of law have occurred. Only the courts have that authority. We offer opinions and guidance, but we do not make determinations as to whether a violation of law has occurred. Second, the town boards are required to post records that are scheduled to be discussed during an open meeting to the extent practicable 24 hours prior to the meeting. If they don't do that, that would seem to be inconsistent with the requirements of the open meetings law. That's what I can advise. Next question is, does this provision require all documents in the monthly board packet be posted online before the meeting? The answer is, if the record is scheduled to be discussed during an open meeting, it is required to be made available at least 24 hours prior to the meeting. So if board members are going to discuss those documents, then the answer is yes, needs to be posted. Are there specific video conferencing platforms that are allowable? If a public body has a resolution in place and procedures, does this need to be posted? The answer to the first question is it's not addressed by the open meetings law about what platforms can be used, but it does need to be something that allows for give and take, for example. There's so many specifics relating to video, these extraordinary circumstances video conferencing. I had to sort of carve it down a little bit for this program, but I'll address some of them quickly now. So for example, if you are allowing one of your members to attend via extraordinary circumstances video conferencing, you have to allow the public to attend via video conferencing as well. If you open up your meetings and allow for a public comment period, which is not required by statute. Under the open meetings law itself doesn't require public bodies to set aside time for public comment or public participation. However, once a public body decides to allow for public comment or public participation by members that show up in person to their meetings, then they also need to allow members that are attending via video conferencing to to have a time set aside for them to have public comments or public participation. Whatever rules you establish for the people that show up in person, those same rules would apply to the people that are attending remotely. So the video conferencing platform has to have some sort of mechanism to allow members that are of the public that are attending remotely to speak if your public body allows for public comment. The question also had to do was whether the public body has to have the resolution. If the public body has a resolution in place and procedure, does it need to be posted? The procedures need to be posted. So there's a provision of the statute that states that the video conferencing procedures need to be posted on your website. If the board is discussing inter-office draft material and/or internal computations that are not final determinations, are those materials required to be posted? If the record is available under the Freedom of Information Law, it's required to be posted. When you're talking about interagency material, once a board starts discussing the content of documents that would have otherwise be considered to be intra-agency material, you're sort of waiving the intra-agency material exception to right of access under FOIL. So you've got a draft memo, for example, or a draft document of any sort. And once you start discussing the content of that draft in an open session, you have waived the intra-agency material exception. The point of this provision, the point of section 103E, which relates to record scheduled to be discussed, is to allow the public to follow along with the conversation. So whatever the board members are looking at and discussing, the public should also be allowed to look at and discuss. And if the board members are discussing things where and they're not referencing names because maybe there's a specific employee where there's disciplinary matters, well, of course, that's probably going to be discussed in executive session. And you don't need to make records scheduled to be discussed in executive session, open to the public. But if you're discussing intra-agency material and you're discussing the content of a document in public, then yes, that record should be made available to the public. In that same question, someone mentioned internal computations. When you say the word computation, to me, that means data. Data is always required to be disclosed. Factual information, regardless of whether it's non-final, it's data is always required to be disclosed. Someone has asked, if your board is developing a law and reviewing / discussing various versions during work session, must the latest version be published with the agenda? The record that you're scheduled, that you are planning to discuss, is required to be made available. That's what the open meetings law states. Any proposed, when you're talking about discussing various versions, whatever you plan to discuss during the open meeting should be available to the public. If you are thinking about discussing multiple versions of a proposed law, then all versions of the proposed law should be made available. So it's section 103E of the open meetings law that requires that records scheduled to be discussed in all proposed local laws, resolutions. That's what we're talking about. Can a body require the public participating via video conference to submit their comments prior to the meeting, but not require the public in person to submit their comments ahead of time? No. The same rules that apply to the people that show up in person apply to the people that are attending via video conferencing. If you have a member a member of your public body attending via extraordinary circumstances video conferencing. The rules relating to public comment and public participation only apply if one of the board members are attending via extraordinary circumstances video conferencing. And if that's the case, whatever you let your people that show up in person do, you have to let the people that show up via video conferencing do. Should the minutes record the public comments and identify the persons making the comments if possible? That is at the discretion of the person who is taking the minutes. The minutes only need to include, let me go back. Got multiple screens up and it's making things funky. Minutes must include a record or summary of all motions, proposals, resolutions, or any matter formally voted upon and vote thereon. That's essentially it. That's what the law states. Nothing beyond that needs to be included. The rest is at the discretion of the person who's been designated to take minutes. When the board is discussing staff's proposed wages next year, raises as part of next year's budget, does that need to be posted in the board packet online? I know people are going to get frustrated with me, but I just need to keep repeating myself. It's any record scheduled to be discussed during an open meeting. If you plan to discuss a record during an open meeting, if you have a document in front of you that discusses wages and next year's raises as part of next year's budget, then certainly that record needs to be made available to the public at least 24 hours before the meeting. Back to my slides. Recording. Any meeting of a public body that is open to the public has to be open to being photographed, broadcast, webcast, or otherwise recorded and or transmitted by audio or video means. An agency is not obligated to record its own meetings unless one of its members is participating remotely under Section 103A of the law, the Extraordinary Circumstances Video Conferencing. An agency may establish reasonable rules to limit disruption and interference, and we have model rules on our website if any agency would like to use them as a reference. Executive session. Executive session is defined in Section 1023 of the Open Meetings Law as a portion of an open meeting that is not open to the public. An executive session should never occur prior to or separate from an open meeting. In order to enter into executive session, a motion must be made in open session and voted upon during open session. And then once that motion is passed, then a public body is permitted to go into executive session. But you can't go into executive session unless you first have an open meeting. The motion to enter into executive session has to be specific enough to reflect to the public and to fellow board members that the board is entering into executive session for a proper purpose. And the courts have spent a ton of time, spilled a lot of ink on this issue as to what constitutes a specific enough motion for entering into executive session. I'm going to go over the reasons you're allowed to go into executive session, but I'll just state two things. One is that yes, it needs to be specific enough to reflect that you're going in for a proper purpose, but doesn't need to be so specific that you're defeating the purpose of the executive session. And two, it should not merely parrot the language of the statute. So for example, here up on the screen right now, you see all of the reasons you're allowed to go into executive session. If you don't see it on this list, that means the conversation is not appropriate for executive session. I will point out that executive session is one of two mechanisms for meeting behind closed doors, and I'm going to talk about the second one in a little while, but this just relates to executive session. If someone wants to make a motion to go into executive session, the courts don't want to see, first of all, a motion should never just say, I move to go into executive session. Certainly not enough. Sometimes we even see it's not even that good. Sometimes we just see maybe the chair of the board saying, okay, everyone, we're going into executive session now. That's certainly not good enough. You need to make a motion that contains sufficient details, specific details about why you're going into executive session. Then it needs to be voted upon. One of the reasons, for example, for going into executive session is discussion regarding proposed, pending, or current litigation. The courts don't want to see you parroting the language of the statute. So, for example, your motion should not just be, we move to go into executive session to discuss litigation. The courts want you to identify the litigation. They want you to say, we're going into executive session to discuss, O'Neill versus the city of Albany or something along those lines. that's what you're supposed to do. You're supposed to identify the litigation. Another example is letter F allows a public body to discuss, hold on, the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. Many public bodies like to shorthand this by saying we're moving to go into executive session to discuss personnel matters. The courts hate it. If you ever get sued under an Article 78 proceeding as a public body because you continually make motions to enter into executive session to discuss litigation and personnel matters, their courts are probably going to slam you for it because it's not sufficient to reflect that you as a board understand what you are and are not allowed to discuss in executive session. Letter F really relates to discussions relating to specific individuals. So you may, for example, maybe you have a job opening and you want to discuss the applications you've received for a particular job opening. You can simply say that. We move to go into executive session to discuss the individual's applications that we've received for such and such position. Maybe there's been an allegation of misconduct against one of your employees, and you need to go into executive session to discuss what steps you want to take relating to these allegations. So the motion may be, we move to enter into executive session to discuss the employment history of a particular person and possible disciplinary action against that person. No, you do not need to identify the specific individual. You just need to be specific enough to reflect that you're going in for a proper purpose. So the two that I've already mentioned are probably the two most common reasons for going into executive session, discussing proposed, pending, or current litigation. And here I'll point out that the word potential is not used. The word possible or prospective litigation is not used. It's proposed, pending, or current litigation. This means you need to be discussing actual litigation, or perhaps someone has filed a notice of a claim and that reflects a clear intent to sue. You cannot use this provision to discuss matters that may potentially down the road lead to litigation. If that were the case, a public body could discuss almost anything they wanted to in executive session because every decision a board makes has the potential to lead to litigation. That is not permitted to be discussed in executive session. Things that have the potential to lead to litigation cannot be discussed in executive session. Only actual litigation, proposed, pending, or current litigation. And the other one that's common is discussion relating to employment histories or employment actions relating to particular persons or corporations. A third one that is common is the discussion of proposed acquisition, sale, or lease of real property or securities, but only when publicity would substantially affect the value thereof. So for example, if a governing body of a municipality is considering purchasing a piece of property, and they want to discuss how much they're willing to offer, that conversation could occur in executive session because they don't want to let the public, the opposing party to know how high they're willing to go. All right, take a little break here. I think we just have maybe one more question that came in since the last one. All right, the next comment was just a comment, it was not a question. The second avenue for meeting behind closed doors is when a discussion is subject to one of the exemptions set forth in Section 108 of the Open Meetings Law. So Section 108 of the law sets forth 3 exemptions. And if one of those 3 exemptions applies, the Open Meetings Law does not. It's as if the Open Meetings Law does not exist. Three exemptions. The first one is judicial or quasi-judicial proceedings, except for proceedings of the Public Service Commission and zoning boards of appeals. So an example might be at a Board of Assessment review. Board of Assessment reviews sometimes have quasi-judicial proceedings relating to real estate assessments. And those quasi-judicial proceedings, hearings that lead to a final determination on the part of the municipality, can be exempt from the open meetings law. That's one example of a judicial or quasi-judicial proceeding that is exempt from the open meetings law. Deliberations of political committees, conferences, and caucuses are exempt from the requirements of the open meetings law. So for example, if you have a 5-member town board and 3 of those members are Democrats and 2 of those members are Republicans, those 3 Democrats are permitted to meet whenever they want, wherever they want, and discuss whatever they want, including both political and public business, without having a meeting subject to the open meetings law, even though they represent a quorum of the board. They can't vote, they can't take action, but they can discuss whatever they want. That is an exemption from the open meetings law. The third exemption is discussions of any matter made confidential by federal or state law. A very, very common example of this is when a public body wants to meet with its legal counsel for the purpose of requesting and receiving legal advice. So this is not executive session. This is where a public body wants to receive the advice of counsel, legal advice, and that conversation is covered by the attorney-client privilege. That is, the attorney-client privilege is codified in New York State statute, so it is a matter made confidential by state law, and therefore, whenever that attorney is playing an active role in providing legal advice to its client, for example, the town board or the city council or the county legislature, then that conversation is exempt from the requirements of the open meetings law. So I'm just going to look to see if we have questions. Someone says, if we have an accident report involving a student, can the school district request a copy of the accident report? That seems maybe a FOIL question if we're talking about requesting an accident report from the law enforcement agency that prepared the accident report. I'm not sure if it seems under, I mean, I'm not really sure how this relates to the open meetings law, sorry, but yes, I mean, accident reports are records subject to rights of access under the Freedom of Information law. Whether the law enforcement agency discloses it to you in whole or in part is going to depend on content. Someone asked, would it be a best practice to cite Public Officers Law Article 7, Section 103 in the motion? I don't know that you need to reference the statute. You just need to use language, because honestly, most people in the audience are not going to be familiar with the specifics of the statute. So for example, I mean, Public Officers Law Article 7, Section 105 is where all of the reasons for entering into executive session are set forth. You know, I mean, I deal with this every day of my life, so it's, you know, it's off the top of my head, but even people who deal with the open meetings law fairly frequently may not know that Section 105 is the section that that relates to executive session. I don't know that it's best practice to use the language of the statute or the citation to the statute. It's most important that you're using language from the statute that reflects that you're going in for a proper purpose. So instead of saying, I move to go into executive session to discuss Public Officers Law, Article 7, Section 105, I would say a motion to go into executive session to discuss the employment history of a particular individual. Another question is, would a complaint made to a Human Rights Commission that is about possible discrimination be appropriate for executive session to protect the person who made the complaint and the person or agency that it is against until more research has been performed? If it involves if the situation involves the employment history of a particular person, if it involves, I mean, I would imagine that a human rights complaint would probably involve a discussion relating to the employment history of a particular person. So if that's the case, then yes, a complaint made to a Human Rights Commission could be appropriate for executive session. So enforcement, you're with me this morning. Again, I'll repeat, the Committee on Open Government does not have enforcement authority. We provide advice about the open government statutes, the Freedom of Information Law, Open Meetings Law, Personal Privacy Protection Law. We don't investigate complaints. We don't issue counseling memos or dunning notices. We provide advice about the open government statutes. Enforcement is through the initiation of an Article 78 proceeding in state Supreme Court. A successful petitioner, if the petitioner succeeds in bringing the Article 78, the court has the authority to award costs and attorney's fees. If the court determines that the violation of the open meetings law is substantial enough, it could invalidate the action. And it can also require that you take training from our office at the Committee on Open Government. So that is the enforcement mechanism of the open meetings law. The person who had the question about Human Rights Commission said it could be about housing. I think what you might need to look to is whether there's a provision of the public housing law that makes that conversation confidential, because there's a good chance that if there are confidentiality statutes associated with the complaint, for example, then it would be an exempt conversation under Section 108 as opposed to executive session. Someone said, should a board be specific and not just read the entire wording of F? Yes. Can't say it enough. You should not just be parroting the language of the statute as a board. You should be picking the sections that are relative to the actual conversation that's going to occur. Be specific enough to reflect that you're going in for a proper purpose, but not so specific that you defeat the purpose of the executive session. So, that is the end of my PowerPoint presentation. If anyone has questions that they didn't have a chance to submit while we were talking, or for some reason I missed it, please feel free to reach out to us. Or go back to the beginning here. I think see if I can pull that up again for y'all. If it's still sharing. Yep, it is still sharing. Yay. Pull it up. Oh, went too fast. There we go. You don't necessarily need to speak to me. I'm happy to talk to people or answer people's questions, but we have other attorneys in the office that can help you. So you can call and just ask to speak with an attorney, or you can email thecoug@dos.ny.gov, and the first attorney that has an opportunity to do so will get back to you. Let's see, someone had a question. Let's see, hold on a second. I'm trying to get back to my questions. Someone said, if a resolution or local law is on the website before open meeting, do you need to have physical paper available at the meeting? This is a good question. My recommendation is to have maybe a couple of paper copies available at your meetings. If you are finding as a public body that it's becoming unnecessary, that no one ever takes advantage of those, do I think you need to have a copy for everybody that shows up, that you anticipate showing up? Absolutely not. I don't want to have you waste trees. I think what I would recommend is letting the public know that if they would like copies and can't access the website, please submit a request in writing before the meeting. But yes, I just think it's a good idea. There's nothing in the statute that specifically addresses it other than the records must be made available upon request at least 24 hours prior to the meeting. Another comment is, I believe last year you said that Coog suggests that board members have a nameplate in the public meeting. This is interesting because when the amendment to the open meetings law allowing for extraordinary circumstances video conferencing went into effect, there was a requirement that all members, so only if you have a member attending via extraordinary circumstances, there's a requirement that all members be able to be seen, heard, and identified. So during COVID, you might recall, there was no obligation for members who are attending remotely to have their cameras on. They could be just by teleconference or they could be video conferencing, but with their cameras off. That's not allowed anymore. You always, if you're a member attending via video conferencing, cameras on, you have to be seen, heard, and identified during all portions of the meeting except for executive session. But there's that extra word, identified. And it doesn't just say that the members attending via video conferencing have to be seen, heard, and identified. It says all members need to be seen, heard, and identified. So it seems to indicate in some way that the public should be able to know who's talking. So if you log on via WebEx or Zoom, you certainly need to type in your full name. If you're the member attending via video conferencing, when you log on, you need to put your whole name in there and not just maybe a nickname or a phone number. But it also doesn't limit that requirement that the members be identified to just the people attending via video conferencing. So I guess it's not a bad idea to have all members have some sort of identification, or at least to introduce themselves. I know, like, for example, at our meetings, we always ensure that our members introduce themselves at the beginning of each meeting. Someone asked whether the town clerk has to attend executive session. So here, the only people that are entitled by law to attend executive session are the members of the board. If the board is going to vote, they either need to invite the town clerk into the meeting for that specific part where they are voting, or they need to designate someone else to take minutes for that vote. But there's nothing in the open meetings law that requires or even authorizes the town clerk to attend executive session. Someone asked about the slides, and as I mentioned in the beginning, the slides are available on our website, opengovernment.ny.gov, and then go to the section that says, I would like to view training and materials. So that was the end of the questions. Thank you very much, everyone, for joining me today. And again, if you have follow-up questions that you didn't have a chance to get to me, feel free to shoot us an email at thecoog@dos.ny.gov, and we'll get back to you as quickly as possible. Hope you all have a great day. Thank you.